Rawteur, Sophia Stewart claims that this manuscript, The Third Eye, was stolen and used to make both The Matrix and The Terminator. Also, this is an actual copy of her lawsuit with the Wachowskis, Warner Brothers, Gale Ann Hurd, James Cameron, etc. And in this video, I'm gonna go through all of it. We'll start at the beginning of the lawsuit and eventually get to the manuscript once she starts providing evidence. All of these documents are available, conveniently provided to you for free of charge on rawteur.com/Sophia Stewart Matrix Terminator lawsuit. It'd be linked below and above in the icon right here as well. According to the court record, she describes several versions of this manuscript. One was a 6-page screen treatment created around 1981, which was copyrighted February 2nd, 1983. Another was a longer manuscript created around 1983, which was copyrighted February 6, 1984. Now, in her lawsuit, she claimed these materials were submitted to people connected to major studios and eventually made their way to the creators of the films, The Terminator and The Matrix. The core allegation was simple. Her work was copied. In 2003, the case Stewart versus Wachowski took place in a California federal court. Although only the Wachowskis are in the case title, the defendants of this case include people associated with both franchises. For the Terminator side of the case, 20th Century Fox, James Cameron, and producer Gale Ann Hurd. For the Matrix side, Warner Brothers, the Wachowskis, producer Joel Silver, and some other parties. Now, Stewart accused them all of copyright infringement and also brought additional claims, including RICO allegations. But the central issue was copyright. So, did these films copy her work? Now, in order to prove copyright infringement in court, two things generally have to be shown. First, the defendant had access to the copyrighted work, as in, is it likely that these people who are being accused were able to read her manuscript because they need to read it in order to steal it, right? The second thing Ms. Stewart needs to prove is that the defendants copied protectable expressions, not just general ideas. An example of the difference would be an idea like a future where machines control humanity, right? That idea isn't protectable by copyright law. However, a specific story where humans live inside simulated pods while machines harvest their energy and a hacker named Neo learned the truth about the simulation, that is protectable expression. Think of it like this. Idea equals a concept. Expression is how that concept is written or shown. Basically, specific details. So in a case like this, a plaintiff must show either access plus substantial similarity, or in rare situations, what courts call striking similarity. That means the works are so similar that copying is the only means of reasonable explanation, which in that case, then they don't need to prove access, right? Because if it's like one-to-one, it's obvious that you copied. They don't have to prove that you somehow gained access to it, right? That makes sense. One of the biggest problems in this case was proof of access. For the Terminator portion of the lawsuit, Sophia Stewart alleged that she mailed a 6-page treatment of The Third Eye to someone working in creative affairs at 20th Century Fox. For a common sense perspective, that might sound like enough. If you send a script to a studio and that same studio later distributes a movie that resembles your work, it is reasonable to wonder whether someone inside the company passed that script along. The courts, however, focused on something more specific. Not whether the studio received the material, but whether the people who actually created the movie had access to it. In this case, that meant the writer of the screenplay, James Cameron. Now, in sworn statements submitted in the case from Cameron, he says that he had never seen Sophia Stewart's work, he never met her, nor had he ever heard of her before the lawsuit. The court also noted that Cameron's statement that in Cameron's statement, he completed the screenplay for The Terminator in 1982. Now, this is where a skeptical viewer might pause and say, wait a second, did James Cameron provide proof that he finished the script in 1982, which would have been the year before Sophia Stewart finished her longer manuscript? The answer is no. So, a skeptic might then reasonably ask, could someone at Fox have passed the manuscript to James Cameron? Sure, that is possible. Then, could Cameron's timeline be wrong? Also possible. But the court cannot resolve cases based on possibilities, right? This is where the burden of proof comes in. In civil litigation, the person bringing the claim has the burden to provide evidence supporting it. That means Sophia Stewart had to present evidence that her manuscript actually reached James Cameron. Without that evidence, the court cannot simply assume that the script moved through the studio and reached James Cameron. If courts work that way, anyone who mailed the script to a large company could force writers to defend themselves against copying claims simply because that company later released a similar movie. So the court doesn't start by requiring Cameron to prove when he wrote his screenplay. It starts by asking whether Sophia Stewart can show that he had access to her work. If she had been able to show that connection, the case likely would have moved further, and the timeline of the screenplay would have become much more important. But without evidence of access, the dispute essentially becomes one person saying he copied my work and the other person saying I never saw it. At that point, the court looks for something stronger than speculation, right? And that's where the concept of striking similarity comes in, where copying would be the only reasonable explanation, right? Even if direct access cannot be proven. But there was another problem with the comparison in this situation. Stewart's longer manuscript was completed in 1983, the year after Cameron described completing the Terminator screenplay. So the comparison would have been between Cameron's film and the earlier 6-page treatment. A feature film script is typically 100 to 120 pages. A finished movie like that, like The Terminator, represents a fully developed narrative with characters, scenes, dialogue, and structure. So even if someone had seen a 6-page treatment beforehand, a finished film of that length involves a huge amount of additional creative development. The court had to decide if the movie actually copied her work or if the similarities were just common science fiction ideas. Since there was no evidence the manuscript ever reached James Cameron, the court said there was not enough proof for the case to continue. Therefore, Sophia Stewart would officially lose her case here via summary judgment because, one, she wasn't able to prove access, and two, there would have been no striking similarity since she wasn't able to prove access, because you're comparing a 6-page manuscript to a fully fleshed out 120 plus page film, right? There's no comparison there, right? You can't say that this 120 page fleshed out idea stole from your 6-page manuscript. It just made no sense. Now, as for the Matrix side of the case, it centered on a different allegation. Stewart claimed that in 1986, she submitted her manuscript to the Wachowskis in response to a magazine advertisement asking for science fiction works. Sophia Stewart also argued that characters and story elements in the film corresponded to her characters in her manuscript. Specifically, she submitted a detailed chart that showed Neo was a mirror of her character Icon. You know, Icon means the one, and Neo is an anagram of one. Xers is tank. young 200-pound muscular man. Kev is APOC. The old gypsy hag prophet is the oracle, right? She claimed the prophetic figure in her story corresponded to the oracle. Vashta is Morpheus. Both characters serve the same narrative role in each story. Tryphena is Trinity. And On is Cypher, who plays the role of the betrayer in both stories. So wait a second. We have access, right? She sent her manuscript directly to the Wachowskis in 1986. Plus, you have similarity. All of these characters' roles line up. So why did she lose? Well, the character chart basically said this character in The Third Eye matches this character in The Matrix. But the court didn't just need Sophia Stewart's chart of conclusions. The court needed the actual underlying works in evidence so it could test those claims itself. In other words, the judge needed to be able to look at her manuscript and then look at the films, then compare the actual material, not just her summary of the similarities, right? That is why the court said that the evidence she submitted was too limited, right? The order says that one part of her similarity evidence was a single page of character photographs, and the judge said that those photos didn't let a fact finder compare things like height, weight, or personality in a meaningful way. The court also said that Stewart didn't submit copies of the allegedly infringing films during summary judgment, which the judge treated as fatal to her striking similarity argument. In other words, Sophia Stewart and her legal team didn't even present the Matrix film to the court, right? The court can't just go watch the movie on its own, right? Everything the judge relies on has to be formally entered into the case record as evidence. And in this case, the films themselves were not submitted during the summary judgment stage. So the court said it couldn't perform the comparison needed to evaluate the similarity claims. So yes, they had the manuscript that she submitted, like, look, here's my manuscript, but they didn't have anything to compare it to because they didn't give them the movie. They didn't give them the Matrix to say, okay, you can compare the Matrix to my manuscript. Then, according to the court record, the alleged advertisement she submitted her manuscript to was central to her theory of how the Wachowskis could have obtained her work. However, the case ran into a major evidentiary problem. During the lawsuit, the case entered a phase called discovery, where both sides exchange information and send each other written questions. One tool lawyers use during discovery is called a request for admission. It's basically a written statement that the other side has to either agree or dispute. Agree with or dispute. In the court's summary judgment order, the judge said that Sophia Stewart was treated as having admitted to several key points during discovery. These included statements that no one at Warner Brothers had access to her materials before the first Matrix film, that the Wachowskis did not place the alleged magazine advertisement, and that she never submitted her work directly to the Wachowskis. Because those statements were treated as admitted, the judge was allowed to treat them as undisputed facts when deciding the case. However, Sophia Stewart later gave a different explanation for why that happened. According to her, the court was able to say that she admitted those things because her lawyers failed to properly respond to the discovery requests and failed to submit the evidence she believed supported her claims. Let me give you a simple example so that you understand what that means. These are my foo dogs, Kodo and Poto. Yes, like the ferrets from Beastmaster, Kodo and Poto. Okay. Now, imagine if we were in a lawsuit and another lawyer sends my lawyers a written statement that says, Kareem, that's my real name, isn't it true that During your Sophia Stewart video, you picked up Poto and threw him across the room. That statement gets sent to my legal team. Now, if my lawyers respond and deny it, then the claim is disputed. But if my lawyers don't respond properly or don't respond on time, the court can treat that statement as if I admitted to it. So the judge could then say, okay, you admitted that you threw Poto across the room, even though you saw that I never did that, even though that you heard that I never admitted to it. I never said that, right? So according to Sophia Stewart, that's essentially what happened in her case, right? She says the other side made statements during discovery. Her lawyers didn't respond properly. And because of that, the court treated those statements as admitted, right? In this case, those statements included the claims no one at Warner Brothers had access to her materials before the first Matrix film, the Wachowskis did not place the alleged magazine advertisement, and that she never submitted her work directly to the Wachowskis. Those are three damning admissions on record as legal admissions. I mean, there's no winning the case after that. In 2005, the federal court granted summary judgment for the defendants. This means the judge ruled that even if the case went to trial, the evidence presented could not support a finding of copyright infringement. The ruling concluded that Sophia Stewart had not produced admissible evidence showing access or actionable similarity between the works. Because of that, the case was dismissed. She did not win damages, and the court did not rule that the films infringed her work. Therefore, Sophia Stewart is not the official writer of The Matrix. She is not the official creator of The Matrix, nor is she officially the mother of The Matrix. Now, to play devil's advocate, let's say her legal team had submitted the film The Matrix into evidence so that the court could do a comparison, and the legal team actually responded properly to the request for admissions. Do I think it's possible that Sophia Stewart could have won this case? Yeah, I can't lie. She had a decent case. Her legal team fumbled horrendously, right? At the very least, she would have gotten a massive settlement. Therefore, it made sense that she turned around and sued her legal team for malpractice, right? One of the biggest sources of confusion about this story comes from this lawsuit, the one that she had with her legal team. Because after losing the copyright case, Sophia Stewart sued some of her former attorneys for malpractice in federal court in Utah. Now, all but one of those attorneys ultimately were found not liable. Only one defaulted in that case. Jonathan Lubell didn't properly respond to the lawsuit. Ironic, isn't it? We can just kind of guess maybe who didn't do the right thing in the first case. I'm not saying it was him, but I'm saying who knows, right? You decide. So the default judgment in this case with Jonathan Lubell, that's what people online often talk about, but it only applies to Lubell, and it was about malpractice, not about whether the Matrix copied Stewart's work. The court allowed damages related to litigation costs and money connected to the Stewart v. Wachowski lawsuit, right? In the malpractice case, Stewart tried to calculate damages based on the profits of the Matrix and the Terminator films, which by that point had earned billions of dollars. But the court rejected that argument because she was relying on profit figures taken from the internet rather than admissible financial evidence, which is like another ouch, because the way that's worded, it seems like if she was able to actually get some financial documents from someone at the Matrix team, company, whatever, because you know each movie's an LLC, she might have been able to get damages. I don't think that lawyer has billions of dollars, but she might have been able to get something from him if she hadn't taken the financials from the internet. The judge ruled that those numbers couldn't be used to calculate damages in the case. And this is important because headlines about this judgment in the Malpractice case helped create the myth that she had won money from the studios. She didn't. Right? The belief that Sophia Stewart won billions actually traces back to early internet reporting errors. There was one student newspaper article in 2004 that misinterpreted a procedural ruling and claimed that she had won a massive payout. Right? The article was later corrected, but by that time, the story had already spread through chain emails and online forums. Later, fact checks from journalists and legal analysts repeatedly pointed back to the court record showing the case had been dismissed, but the myth continued to circulate. I mean, especially whenever a new Matrix movie is released, and because the Matrix 5 is in development, here we are again. If you like this type of insights in the film and television industry, subscribe to this channel and check out this playlist full of copyright cases.